if it is against their beliefs, and I am voting for that in the hope that it will further add to the record our conviction about that. Mr. Chair, thank you.
I call the honourable member Chris Okenville.
Thank you, Mr. Chairman. I hadn't intended to speak particularly about the referendum, but I will in fact start with that because I am opposed to referenda as a system of decision-making in this type of government. But the proposal to have a referendum is in keeping with New Zealand First tradition, with their practices, and it's what they do, and I respect them for that, and I think they're very sincere in promoting a referendum in this case. They've always liked them, even though they don't always benefit from them. And I think of the Right Honourable Winston Peters, and I think it was compulsory superannuation, wasn't it, when there was a ghastly result to the referendum. So, you know, courage, and one could hardly complain about New Zealand First putting forward that proposal, and I'm sure they'll all vote for it. I won't. The reason I won't is that I'm very conscious, in my mind, that the law should not be used to exclude people, and neither should referenda be used to exclude people. And I think that could be the result of using a referendum in this case. We have heard that it's recommended because it will involve people. What it won't do is inform people. And this is a case where you really do, I think, need a lot of information to come to any sort of a sensible decision. And so a referendum in this case would of itself be divisive and opinion-driven, no matter which way the result might go. The purpose of our being here is to legislate based on the information we have considered. I was deeply grateful to Moana Maki, my colleague at many a committee meeting, for her presentation of facts this evening. It did, I feel, set things in context very clearly. But in this respect, Mr. Speaker, Mr. Chairman, I completely understand the supplementary order papers that are coming forward, because they reflect exactly the same sequence of thought processes which we went through as a committee. The difference is that they've come in at this stage without the benefit that we had of a number of weeks to carefully consider which parts of the bill the amendment should be directed to. In regards to the SOPs, if I may compliment the work done by Sir William Sear and the way it was presented. And again, I'd like to say to that member that I have no doubt about the sincerity with which he approached the task. However, if I may, I have a few arguments against the provisions that have been put forward. The first one about the celebrants, religious and independent. This wasn't something that we treated lightly at all. The Select Committee fully investigated this section, and their amendment, I consider, best reflects the advice that we received on this issue. The current Section 29 and 29A, as recommended by the Select Committee, already provides stronger protection, which has been stronger protection than has been there before. A triple protection is really not going to achieve anything other than increase the chances of litigation. And this is not, I mean, if you look at Section 29, it's pretty sort of general in that, you know, you may but are not obliged to conduct the wedding. And then we made it a little bit more specific for religious people, but if you then go further again, you are becoming more and more specific in specificity introduces new opportunities for litigation. And, you know, honestly, do you really think people want to lawyer up, reach for their lawyers? What are you doing reaching for your lawyers? Well, I'm intending to get married, so I must sue some. I don't honestly think it'll be like that, but we made provision for it. Basically, the Act needs to be read consistently with the Bill of Rights Act and the Human Rights Act. I'm surprised that we have SOPs suggesting that those acts should be negated. What is it you want to do that avoids those? Mr. Chairman.
The Honourable Member Chris Ockenville.
Thank you. The Ministry of Justice expressly stated in its advice to the Select Committee, we were very impressed with the quality of service we got from the Ministry officials. We recommend that the exemption extend to religious bodies and approved organisations, but not to independent marriage celebrants or registrars. A key purpose of religious bodies, and I think this is very important, and most approved organisations is to promote religious beliefs. And therefore there's something that lawyers would understand much better than I, and that is a hierarchy of purpose. So Section 5 of the New Zealand Bill of Rights Act allows rights affirmed under the New Zealand Bill of Rights Act to be justifiably limited. Accordingly, an exemption could be justified where it would be contrary to the recognised purpose of religious bodies and approved organisations to require their celebrants to solemnise certain marriages. In contrast, independent marriage celebrants and registrars are appointed by the Registrar General to perform a public function, not to promote their own religious or personal beliefs. It appears unlikely that they could lawfully refuse to solemnise a marriage on religious grounds under Section 5 of the New Zealand Bill of Rights Act. The Select Committee extended the exemption for religious bodies and approved organisations in Section 29A. When we look at the call for freedom of expression, where it's no challenge may be made under any act to the lawfulness of the following conduct by a person or organisation, provided that the conduct is based on the belief or conviction that marriage should be the union of a man and a woman. I have a few problems with this one, Mr. Chairman, because the Select Committee have removed Section 56 of the Marriage Act that made it an offence to question another's marriage. The removal ensures no person can be convicted of expressing such a view. Incidentally, there never was a prosecution under that section. I have some problem with the drafting of this particular recommendation because what it does say, Mr. Speaker, is that the conviction that marriage should be the union of a man or a woman, it doesn't add exclusively. And so you could easily add after that, or two people of the same gender. So I think the proposals are, from a drafting point of view, riddled with difficulties, especially when we start talking about the need to identify the genders and just who's going to do that sort of thing. Yeah, exactly. Enough. We don't need to start thinking in that direction. But that is one of the difficulties about introducing specific requirements against the bill as it is. The use of premises for marriage, what we understand there, Mr. Chairman, is that no challenge may be made under any act to the lawfulness of a refusal by a religious body or approved organisation to allow premises, being premises that are occupied and used by the body of the organisation for or in association with its religious purposes, to be used for in connection with a marriage that is not a marriage between a man and a woman. There is a fundamental difference, Mr. Chairman, between private and public spaces. We don't leave it to churches and organisations who determine whether they sell their services or not. We should leave the bill as it is, and it protects religious freedom, and the Human Rights Commission has been clear that there's a distinction between private and public places. Mr. Speaker, I really understand where these submissions are coming from. I understand the impulses that have brought them forward. It's not strange to members of the committee. We have been through the same processes. I think given time, people will come, as Moana Maki said, pretty much we're fairly close to where we would have been. I think we can move forward and trust the bill. We should pass this bill. Thank you, Mr. Speaker.
I call the Honourable Member Sua William Sio. Te lawful lava.
Chairman, I just want to take a short